Hi, everyone. I'm Rui-Jie. I'm a PhD student at Brown, and I'm really excited to be here to talk about our work, Red Teaming AI Policy, a Taxonomy of Avoision, and the EU AI Act. And this is work that I did jointly with Bill Marino at Cambridge and my advisor, Suresh Venkatasubramanian. So I'm going to start with a little bit of a provocative quote, which is that power interprets regulation as damage and roots around it. And there are lots of different ways that this rooting around can occur, through things like evasion, lobbying, even rhetoric or information creation to steer policy or policy discussions in one way or another. But the rooting around that we focus on is avoision, which is the avoidance of laws in ways that evade the law's intent or purpose, but that do not actually constitute unlawful behavior. And we were curious about how avoision might play out in the AI regulatory landscape, and to do so, we evaluated it through the lens of the EU AI Act. At the time we wrote this paper, there were sort of complaints about the compliance costs that the AI Act posed, and these soaring compliance costs then created incentives for behaviors like slowing deployment of AI systems in the EU, even stalling AI features in the EU. And to organize our thinking, we use a taxonomy, we introduce a taxonomy of EU AI Act avoision, where we bundle different avoision maneuvers in different tiers, looking through the Act scope, its exemptions, and its consequential categories. And something that I want to point out is, as we move through these different tiers, there's an increasing exposure to the EU AI Act. So there's an increasing regulatory burden that the EU AI Act poses. So let's start with the scope. To talk about avoision, we first have to lay out a little bit about what the goals of the scope are, which is to have an extraterritorial effect. So whether or not you're based in the EU or outside the EU, if your AI system is placed on the EU market, the EU AI Act is, in some cases, implicated. And this is to sort of ensure a level playing field and a protection of people who reside in the EU. But one way that this might be circumvented around is by distancing AI systems from the EU market in certain strategic ways. In particular, by, for example, adding software or rules-based wrappers to the output of AI systems. And to just give an example, consider a video tag generator, where in order to figure out the most suitable tags for a video, you might use different AI systems, like an image AI model, a visual AI model, like image-based AI systems, and those models might give you a sense of what's important in a video. But you might be able to aggregate those responses, those outputs from those AI systems, by using a rules-based system, and then when the EU user ultimately interfaces with that system, it's the rules-based system that lies closest to the EU market. And this potentially provides an argument that what the EU user is interacting with may not necessarily be an AI system. And now to talk about the exemptions. So the Act has two major exemptions relating to scientific research and development and open source. And in broad strokes, the goals of these exemptions are to promote openness and innovation and to support growth in the EU economy. One way that the research exemption might be exploited is through conducting research without openness, or by conducting research to control and restrict. And this is possible by firms because the research exemption does not explicitly exclude research and development activities within corporations. And so there might be incentives for corporations to conduct research in such a way as to potentially not publish their findings or to structure their AI research in ways by using techniques like patent thicketing, which might deter entry into a particular space. And once that research team might be ready to productionize their AI, the market might be flushed of competitors, and then they might be better able to absorb the cost of regulation, potentially undermining the goals of openness and innovation. And finally, one way that the open source exemption that might be exploited is through open washing, which the fact community might already be quite familiar with, where certain aspects of the model might be kept closed, such as the data sets that the models were trained on, and this might sort of hinder sort of downstream innovations relating to those data sets. And finally, I'm going to talk a bit about the consequential categories. The EU AI Act is famously a risk-based approach to regulation. So there's a regulation of high-risk AI systems, low-risk AI systems, GPAI, general-purpose AI, and general-purpose AI with systemic risk. And in broad strokes, the goal seems to be to minimize threats while promoting market diffusion, while promoting market uptake of these different AI models. There's also different categories of operators. So there's a provider, there's a deployer, with the providers generally having the most regulatory burden. And in broad strokes, the goal here is to have sort of proportionate responsibilities along the AI supply chain. So one interesting way that categories of risk might be circumvented is through using a technique called benchmark shopping or sandbagging. So a general purpose AI system is classified as having systemic risk if it meets the condition of having high impact capabilities evaluated on the basis of things like benchmarks. But by shopping for benchmarks where your model might appear to not have these high impact capabilities, or by training models that might strategically sort of underperform on evaluations, a firm might be able to avoid the categorization of systemic risk. Another interesting way that the categorization of systemic risk might be avoided is through the use of a technique called federated learning. And this is because a GPA model can be classified as having systemic risk if the cumulative amount of computation used for training measured in floating point operations is greater than 10 to the 25. And the thing that federated learning does is that when you're training across these different entities, potentially the number of floating point operations that are used to train your model becomes a little more obfuscated, and it becomes harder to determine the risk that your model might pose. And finally, I'm going to be talking a little bit about incentives at play with categories of operators. One thing that the EU AI Act might incentivize is for downstream developers to constrain their technical changes in ways that might still have a significant impact on the model's performance, but that can be argued to be sort of technically insignificant. And this is because in some cases, if a third party makes a substantial modification to high-risk AI systems that are already placed on the market, you might be absorbing all the responsibilities and the label of an AI provider. And this might come to play through the use of techniques like prompt tuning rather than fine tuning, which would require you to potentially retrain your model on another data set. So this is sort of a taxonomy that we pose. I do want to make, 2 more minutes. I do want to note that there have been a lot of changes in the current regulatory landscape with potential stalling of the enforcement of the EU AI Act. But what I want to highlight here is that this adversarial mindset and thinking through regulations can still be quite relevant to AI regulations that are already in place, for example, in the United States with the FDA Cures Act, where potentially inserting a human or potentially another kind of software between an AI system and its ultimate output or decision might be able to change the categorization that the ultimate system falls in. So I hope that this framework provides a way for thinking through these different responses. So the takeaway that I want you to get is that technological and organizational decisions can matter in the application or the lack thereof of regulations. And this can potentially make ways for developers to build and package AI systems with similar effects as regulated systems, but in ways that avoid scrutiny. And we hope that systematically thinking through regulatory exposure and burden can play a role in forecasting these regulatory responses and ultimately potentially mitigating the harms that come from these responses. This is my email. Feel free to chat. My advisor is also in the audience, Suresh. So yeah, thank you so much.